Welcome back. You're watching Frontrow. This evening we are discussing the efforts in earnest that are ongoing at the Supreme Court to revive the Building Bridges initiatives. The hearings for those who are for the BBI were heard this day, and of course we are digging down to find out what's at stake even as we head towards the 2022 general election. Do we even have the time? Is it practical given that the outcome is positive for those who are proponents of the BBI? And just to reintroduce our guests this evening, Wako Ojiwa is the Executive Director for Siasa Place. Now also we have Suleiman Bashir, who's an Associate Advocate. Remember, you can be a part of this conversation by getting on Twitter. The hashtag is Frontrow, and I'm at Trix Ingaro. Tag me and you can be a part of this conversation. We're asking you today, with only months to the August 2022 polls, what do you think is at stake in the BBI legal battle? Get on Twitter, tell us what you think, and of course be a part of this conversation. Now, we heard all that was said at the Supreme Court. Now, the basic structure doctrine. Narima Wako told us about all the jargon and how it is difficult sometimes to understand what's going on. But this basically means that there must be a difference between amending a constitution and replacing a constitution. Bashir, is that a good layman's interpretation of the basic structure doctrine?
I think Trix, the whole, to put it in simple words,
yes,
the concept or the principle behind the basic structure doctrine and what is going on at the moment before the Supreme Court is whether or not it is applicable in our country. In short, can certain provisions of the Constitution not be amended at all?
Yes.
The unamendability aspect of certain provisions of the Constitution. In other words, are there any protected provisions of our Constitution? And I think one of the key provisions that is under discussion before the Supreme Court is Article 89, which is about the aspect of IEBC having the power to delimit the boundaries.
Right.
And you know what comes in is the aspect of the 70 additional constituencies that were brought in by the proponents of the bill. So the question is, can the people of Kenya amend the Constitution to introduce extra 70 constituencies? That is the big question. Whilst we know that under Article 89, it is only the IEBC that can delimit the boundaries. It is only the IEBC that can tell us, Langata constituency shall be from this point to this point. So that is the big question. So it is about, are there certain provisions that cannot be touched at all?
Yes.
And I think that is one of the issues that we expect the Supreme Court to give us a determination on. So it is about, are the people, as a people, are we so powerful enough to amend whatever we want about our Constitution, or does it mean that there are certain aspects of our Constitution that cannot be touched at all? Okay,
and she told us in Chapter 1, it says the people are sovereign, so that means then we can.
I think, Trix, the principle behind the reasoning of the judges is that when the Constitution, there was a very important principle behind the drafters of the Constitution.
Yes.
When they were writing the Constitution, they had in mind certain areas of the Constitution that should not be tampered with. That in the event certain provisions are tampered with, they will end up disrupting the whole objective of our Constitution. Right. Yes.
And what you're saying reminds me of a comment that was made that said that basic structure doctrine is an unruly horse. What do you say about that?
I think it's something that we do have to talk about, because even as we're talking about change, and the fact that when we talk about change, especially something as major as the Constitution, how often can we change? How easy can it be to change, or can we change it at all? And I say we need to have this conversation because if you even look at neighboring countries when it comes to even constitutional amendments, we have seen presidents go ahead and make a whole constitutional amendment without even due process and public participation. And we are not that different. These are our brothers and sisters, just living in different boundaries in different countries. So it can happen to us. So when we are thinking in that aspect, just because we have an individual who, say, comes into power and thinks they have absolute power. So now when you even talk about boundaries, we are talking about power. That's it. So it's about who can control what and when. And so that also goes back to what we're talking about, the Constitution that says the people have direct power. But we also need to realize that we also give this power, our power, to representatives.
Through
and there
elections
needs
and
to be some guards in terms of accountability. So we do also want to talk about, yes, I want to change it because I can change my mind. But you don't want it to be changed too easily. So it's a tough balance. And I think that's where a lot of people are not going to be able to agree. And it's a decision that, like I said, is going to affect the future of this country in terms of how youth even engage in politics and how we can even determine whether an issue or an amendment can be changed in our constitution.
Okay. Yes, Bashir?
Trix, I think when it comes to amending the constitution, I think in my considered opinion, when we talk about the principle of the basic structure doctrine, does it mean that we may not be in a position to easily amend our constitution? Does it mean that the mechanism that we have in our constitution, is it too easy to amend at the moment? I think, in my view, when you look at Article 257, it is not very easy to collect 1 million signatures. It is not so easy to convince at least 24 county assemblies. It is not easy to, again, have to majority of the members of the National Assembly and the Senate pass it. I think these are special gateways that is not easy to be passed through by any promoter of a bill. I think the safeguards we have under Article 257, in my view, are already quite onerous. So it is important that we make it onerous but not impossible. Applying the basic structure doctrine may end up making amending the constitution so impossible. So let amending the constitution not be impossible, but let it be onerous. Let it be a bit difficult. And I think the safeguards we have under Article 257, it's not so easy for any single person to easily have your way around it. I think the safeguards we have are enough. Employing the basic structure doctrine at this stage, I think, in my opinion, may end up being so difficult such that very important aspects of it may be so difficult to maybe amend it. I think going forward, even as we await the determination of the Supreme Court, it is very important that all of us go back to Article 257 and see. I think those safeguards are not easy to attain already.
Absolutely. To add on that. I agree with you, but to some extent, even to be able to go through those levels that you have explained to us very well, there's one thing you have to have: money. You have to have money. Even when we talk about recalling a member of parliament, for you to be able to do that, so to have money, you're a person of influence, which means you have power. So it goes back to the minority of this country. So it's a specific individual you're talking about. It's not the majority population. A young person cannot come in this country and say, I want an amendment to the constitution. I have 1 million
They have the right
signatures.
to, though.
They have the right.
Yes.
But they don't have the capability to follow through. And to me, that's the importance of this conversation. How can we actually make it an actuality for all when we say it's all people? But this discussion, those levels exist, but we're not talking about it in the reality, the actual context of this country, which is the wealthy are able to control a lot that happens in this country. How can we even that platform?
Absolutely. And there's the argument for the president that he is also a Kenyan and therefore has the right to initiate a change to the constitution. What do you say about that from what was said today?
I think, Trix, even as you await the determination, the general argument was that as the president of a country, there is a certain channel that you may use to amend the constitution. For example, it is not just this specific Constitution of Kenya Amendment Bill that the President has tried. There are a number of bills that the President was able to front through the office with the Attorney General. So I think the reasoning behind the judges was that the head of state already has a platform to go through in the event he is interested in maybe pushing through certain amendments. And I think the other argument is what Nerima has actually rightly put, such that the influence that he may have, he may end up taking advantage of a specific position to maybe sway the minds of Kenyans to ensure that certain amendments are done to the Constitution. But Trix, when you look at Article 257, it talks about 1 million registered voters. 1 million registered voters. It's not just 1 million Kenyans. So it is about getting 1 million registered voters that shall be forwarded to the IEBC for scrutiny. You can imagine such that by the time you are forwarding, you will even think of forwarding 3 million signatures of registered voters. And I think such that by the time the IEBC is done with vetting, it remains with about 1 million. That tells you that that process itself is not so easy. I think when you look at the BBI, the promoters were so many that such that they gave it a concerted effort, and that is how actually they were able to make it through. Yeah. But I think the process as it is, it's quite complex. On the part of the president, whether or not he should be allowed to maybe front an amendment in his personal capacity or not, or whether or not this particular bill was fronted by Dennis Waweru or Honorable Junet Mohammed, is something that the Supreme Court shall determine. And I think it is a wait and see issue, but one of the arguments that actually was actually put forth by his advocate was that the president has actually sworn by this constitution that he will uphold and protect it. By dint of him swearing by this constitution, it means he has a right to subject himself to the provisions of this constitution. On the other part, Article 257 does not exclude him from being from any other person. It talks about any single Kenyan. So the argument is, again, he is a Kenyan by dint of that specific provision. But all said and done, I think we need to await the determination of the Supreme Court on this particular issue. Yeah, because the argument was that anyone can petition Parliament to deal with said amendment that is being sought. Now let's talk about the practicality of it all. The year 2022 then is going to be hectic. Let's say if we can look forward and say maybe this goes in favor of the promoters of the BBI. What do you envision? And do you think this country is ready for that kind of, I don't know what to call it, it's a mixture of political and civic turmoil, if I can put it that way?
I would say that we're in a position where I feel there's so many other issues that we are dealing with, especially economically. And every time we are in an election year, we have seen our economy suffer. A lot of investors pull out because of the uncertainty. And to top it all off, we do have COVID that is still amongst us, 2 years going. And so there are already those. And then we want to add now this. I think it's going to happen. I mean, if they want it to happen, it will. Kenyans, there's nothing about are we ready, because somehow we get ready. You know, it's just going to happen and we will prepare for it. So I don't even think that's the question, because I do believe that if there's so much political will to make it happen, it will happen. And I keep saying, even some of these bills that have had special sittings, and sometimes they've been in assembly until midnight to make sure that it passes. It will be the same momentum to make sure that this happens if they want it to happen. So it's not something that's completely in our control, and it's something that we will find ourselves lining up to do if we're told that this is the moment to do it.
Absolutely. Now, ideally, there's also the question of the number of questions. Bashir, where do you stand on that?
I think, before I get to the number of questions, there's, I think the question of the number of questions emanates from the Elections Act. Because as a country, we do not have a specific framework that governs our referendum process. So I think the provision talks about Parliament having a say on the question, on how the questions shall be formulated. Ultimately, Parliament shall approve whether or not we shall have a multi-faceted questions or a single issue question. But I think, to answer your question on the practicality aspect of what we are having before the Supreme Court, is that we have 7 intricate issues that the Supreme Court shall determine. Away from these 7, there's a general issue that the Supreme Court shall make a commentary about, which is, does the Constitution of Kenya Amendment Bill of 2021, was it done in accordance with the Constitution of our country? In the event, holistically, it will be yes, it will breathe a fresh life into the process, and the promoters may be interested in proceeding with the referendum process. On the other part, we have critical questions such as the referendum question, such as the question of quorum of IEBC. The key question is, as at the time of vetting or scrutinizing the signatures, the commissioners who were in office were 3. Was the quorum in order? In the event that quorum was never attained, it will deal a blow on that specific bill. On the other question of the president being a promoter, in the event otherwise it's decided by the Supreme Court, it will equally deal it a blow. So I think once these specific 7 issues succeed, that is how holistically the Constitution of Kenya Amendment Bill shall be given the green light. And it is from there that we shall ask ourselves, is it really reasonable or is it practical on the part of the promoters to proceed with this? I think one of the key issues that I wish to personally look at it is, we have 70 additional constituencies that were proposed by the promoters. The big question is, even assuming the Supreme Court gives it the green light, what happens? What will happen is we find ourselves back to Article 89. For you to introduce 70 constituencies, you need to maybe, let's say, I think Mandera County was awarded 1. it is up to IEBC to tell us where this constituency shall be placed. So it is IEBC to again delimit the boundaries to create that space for that constituency. But look at again that Article 89. It talks about if any delimitation happens, it ought to be done at least 12 months to the general election for it to be considered. Meaning, in the event even it goes through, or even in the event the boundaries are delimited in line with Article 89, this may not be impactful at the moment until the next general election, because we are less than 12 months away from our general election.
So legally speaking, it cannot happen.
In my considered opinion, and I think in line with Article 89 of the Constitution, I do not see it going through. But I'm still a bit skeptical about commenting a lot, noting that there is aspect of sub judice, and this is a live matter before the Supreme Court.
Absolutely. Nerima, would you like to add?
I love how you said in my considered opinion.
Because yes. But, yeah, I mean, let's also talk about the issue of the president's immunity. Let's listen to a clip before we get our guest's final opinion on that as we conclude the conversation.
Government must perform their duties, but must operate and must operate effectively, and that includes the executive, which is headed by the president, and the legislature, which is headed by the speakers of the two houses, and then the judiciary. So in determining this question, why was it necessary for the president to be granted immunity under Article 143(2) of the Constitution? And my lords and my ladies, the answer is simple. First, it is necessary that the president has decisional freedom to make decisions that are key and important to safeguard the interests of the country. He occupies a unique position in which on a daily basis he has to make decisions that affect the lives of Kenyans.
All right, now because we were pressed for time, and like our opinions on that, quite short, please. Let's start with you, Nerima.
It's an interesting argument because on several aspects it is correct that he is a representative when it comes to the president and being Kenyan. And the fact that it's a matter of national interest, he also has to have an opinion. He's not a figure that is not supposed to speak or have an opinion.
Yes.
So I do think that it's going to be a very interesting debate because we cannot forget that him being a promoter, there's an influence that comes with it.
Of course.
So as much as we earlier spoke about a lot of promoters, the bigger question is, do we really have freedom of association and speech?
All right.
Because we did see when people didn't technically support BBI, they lost position and they were kicked out and they were muted. And so that also needs to be put into context.
All right, Suleiman.
I think on the question of whether or not to institute civil suit against the president, I think I have been following the argument that was put forth by my learned senior Kamau Karori. I think he makes a lot of sense. The head of state needs ample time and opportunity to steer the operations of the country. In the event you are able to institute direct civil suits against him, it may end up diverting his attention from the common good that he has for the country. I think on the flip side, if anybody has maybe a suit to maybe level against the government, it is that we occasionally do, because ordinarily suits are leveled against the state through the office of through the state law officer's office of attorney general. That is what has been happening to address or to challenge governmental decisions at the moment. I do not see it being a big deal, but I think it is unnecessary at this stage to even consider such a move to maybe institute civil suit against a sitting president, in my opinion, even as we await the determination of the court.
Even as we await the determination of the court. Thank you very much. That is Suleiman Bashir. He is an advocate. We also had Nerima Wako Ojo, who's the executive director, Siasa Place, and that draws Frontrow to a close. Thank you so much for your participation online. You can keep the conversation going. The hashtag is Frontrow. I am at Trix Ingado. But for now, it's goodbye.